The Section 8 notice procedure is important for landlords seeking possession of a property let to an assured short-hold tenant. Currently, it is one of two routes to possession for private landlords, alongside the Section 21 procedure, commonly referred to as no-fault eviction. The Renters Reform Bill will abolish Section 21 notices. This will make Section 8, the ground-based procedure, the standard for all possession claims against private tenants. My name is Sarah Cummins, and I'm a Senior Associate at Anthony Gold Solicitors here in London. Today we will talk about Section 8 notices under the Housing Act 1988. So, what exactly is a Section 8 notice? A Section 8 notice is a statutory notice seeking possession. Section 8 notices require the landlord to set out a ground for possession, for example rent arrears. It's therefore different to a Section 21 notice, where the landlord does not need to provide a reason for seeking possession, although they do need to comply with certain preconditions. So why would a landlord use a Section 8 notice over a Section 21 notice now? A landlord may opt to serve a Section 8 notice if they are unable to serve a Section 21 notice. A Section 21 notice cannot expire before the end of the fixed term of the tenancy, unless there's a break clause. So during the fixed term, a Section 8 notice may be the landlord's only option. Where a landlord has the choice of relying on a Section 21 notice or a Section 8 notice, they may choose to serve a Section 8 notice as the notice period may be shorter. For example, if a tenant is in rent arrears, the notice period is currently 14 days. The landlord can then apply to the court for a possession order more quickly rather than wait for a 2-month Section 21 notice to expire. Which notice to serve will depend on the circumstances of each case, and there is nothing preventing a landlord from serving both types of notice simultaneously. Once Section 21 notices are abolished, landlords will only be able to recover possession by serving a Section 8 notice. When can a Section 8 notice be used? Not all possession grounds can be used if the tenancy is still within its fixed term. For example, when using ground 6, the redevelopment ground, the landlord cannot recover possession until the fixed term has ended. Other grounds, such as ground 1, which covers owner occupation, require the landlord to have provided the tenant with notice before the start of the tenancy that they may later seek to rely on the ground. If a landlord wants to rely on a ground that can be used while the tenancy is still within its fixed term, they also need to check that the tenancy agreement itself allows the landlord to bring the tenancy to an end on that ground during a fixed term. The only exception to this is ground 7b, which concerns the lack of a tenant's right to rent because of their immigration status. The Renters Reform Bill will abolish fixed-term tenancies. However, landlords will be prevented from relying on certain grounds in the first 6 months of the tenancy. For example, ground 1, which covers occupation by the landlord or a family member, and the new ground 1a, which deals with a landlord's intention to sell. To prevent abuse of the new grounds, there are proposals to make it an offence if a landlord serves a Section 8 notice earlier than they are entitled to. What grounds can a landlord rely on? The possession grounds are set out in Schedule 2 of the Housing Act 1988. For example, a landlord may serve a Section 8 notice if the tenant is in rent arrears, or they have breached the term of their tenancy. There is a mix of mandatory and discretionary grounds a landlord may rely on. If the court is satisfied that a mandatory ground has been established, it must make an order for possession. With discretionary grounds, the court may only make an order for possession if it's reasonable to do so. The Renters Reform Bill will change the grounds for possession, amending some of the existing grounds and creating new grounds. As the bill is still proceeding through Parliament, further amendments are expected. If you have any queries about Section 8 notices or need guidance in this changing legal landscape, we are here to help. Contact us at Anthony Gold Solicitors on 020 7940 4060 or send an email to mail@anthonygold.co.uk.